succession and estate planning, one of the key issues that we are really looking at is what are the goals, what are the major goals of high net worth individuals? Obviously, one of the main goals is to accumulate and preserve wealth, which is designed to safeguard the lifestyle of generations to come. Now, it's hard enough to acquire wealth, but protecting it, preserving it, and passing it over to successive generations is an even greater challenge. It makes me remember a Chinese proverb, which basically says that the wealth of a family never lasts for more than 3 generations. There are a lot of equivalent proverbs across the world, which basically all mean that wealth that has been gained in 1 generation may begin to dissipate after 3 generations. And estate planning is really the process by which a client can anticipate, can arrange during his lifetime for how his estate is going to be disposed when he's not there anymore. There are many purposes to an estate plan, and I'll just mention a few which are going to be relevant for today's session. Obviously, elimination of uncertainties over the administration of probate. Mona would probably be touching on that a little bit later. Maximizing the value of the estate, ensuring that wealth is adequately preserved, protected, utilized, but most importantly passed over. Now, in order to come up with a good estate plan, obviously one needs to look at the tools that could be available in order to come up with such an estate plan. Now, there are a number of tools that can be used to come up with a good estate plan. In the common law world, the trust is one of the most important estate planning tools that are used by high net worth individuals. Trusts have traditionally been used in the context of private wealth management, for centuries. Very often the will is one of the main tools that are used, but there are also other tools such as societies, and even companies can also be used as part of an estate plan. Foundations, on the other hand, are really the new kid on the block. They are a newcomer, but are being increasingly considered by practitioners in the context of private wealth management, but also for charitable giving. A lot of the charitable institutions are set up as foundations, and one that comes immediately to mind is the Melinda and Bill Gates Foundation, for example. And foundations have only been around since around the 1920s. In fact, Liechtenstein was the first country that introduced that concept. But today there are a number of jurisdictions which have a law and a few differences as well. Now, let's perhaps now drill down on each of these different vehicles and just try to understand a little bit more their specificities and also how they can potentially be used for in an estate plan. What makes trusts interesting is that the legal ownership of the asset, i.e. the control in respect of the asset, is vested in the trustees with a number of obligations. So although they would be legal owners, they wouldn't be able to do whatever they want with the property, but they will have to hold and manage that property for the benefit of beneficiaries. And therefore, if they perform an act which they were not supposed to, or if there is neglect on their part, then they would have committed what is called a breach of trust, for which they will be liable. And the trustees would operate within a framework, and that framework would generally be a trust instrument or a trust deed, as it may sometimes be called, but also the framework which is provided by law, which would impose fiduciary duties and non-fiduciary duties on the trustees, but at the same time will give them a number of powers so that they can control and manage the assets for the benefit of the beneficiaries. Now, certain types of trusts, for example, purpose trusts, which are trusts that are set up not for the benefit of people, but for purposes, will also have an enforcer whose duty will be to enforce the trust, as these trusts would have no beneficiaries. A foundation compared to a trust is a legal entity. A trust is not a legal entity, it is a relationship, but a foundation is the dedication of property to an entity that is to be used for a specific purpose or for the benefit of persons. The client who creates the foundation is the founder. The founder would then transfer relevant assets to the foundation, but as compared to the trust, it is the foundation itself that would hold these assets. But then, similar to trust, the foundation would hold the assets for the benefit of one or more people who are called beneficiaries. In terms of governance, a trust is controlled and managed by trustees, whereas a foundation is managed by a board, which makes it quite similar to a company, because it will have a board which will comprise of people who are called council members, who will also have extensive powers to manage the affairs of the foundation. So in that sense, it is quite similar to a trust, because the board would have powers to control and manage the foundation and its assets. The board, the council members, will also be subject to duties, very similar to those duties that apply to company directors. And in both a case of a trust and a foundation, there is a possibility of appointing what is called a protector, who would have certain powers of veto in particular, so that clients can feel comforted that their wishes are being duly taken into account, and also that trustees and council members are not misbehaving. So in a sense, just to sum up, the trust and the foundation are very similar because they can be used for mostly the same type of purposes, but the main difference between the two is that one is a legal entity, whereas the other is not a legal entity. I think the main advantage that a client has by using a trust or a foundation over a will is that a trust or a foundation is not immutable or fixed in time as a will. As a lot of people would know, a will takes effect upon death and would lead to an immediate direct disposition of assets to the heirs after the death of the client. A trust or a foundation, on the other hand, takes effect immediately. It takes effect at the time of its creation, but the assets do not pass to the heirs directly. And this can be very advantageous for clients in the context of estate planning, because it enables those assets to be protected during the lifetime of the client, whilst retaining the benefit of the assets for the beneficiaries. They provide a lot of flexibility and can adapt to changing conditions or circumstances, unlike a will, because a will, once the client passes, the will cannot be changed. It can only be changed during the lifetime of the client. Trust and foundations can provide for the enjoyment of rights to be split on a plane of time, unlike a will. They can provide for rights of donees to be subject to termination, to diminution, to suspension in given circumstances. Again, not possible with a will. They can also provide for philanthropic, charitable objectives. So these are a few advantages of a trust or of a foundation over a will, but there are also other benefits, which arises particularly through the imposition of a structure between the person who is making the gift, i.e. the client, and the person to whom he intends to benefit. Now, in a typical scenario, when you have a will or you make a gift, there is nothing in between. But here you have a trust or a foundation that sits right in between the donor and the donee. Now, imagine these potential situations. There could be a beneficiary who could be incapable of managing assets, either due to age, due to illness, or otherwise. So by interposing a trust or a foundation, instead of making an outright gift, you are able to ensure that there is someone else who could be managing these assets for the benefit of those people who might be minors, who might have an illness or an incapacity. This interposition also allows for ring fencing of assets and is therefore very useful in the context of asset protection, because once you've transferred your asset to a trust or a foundation, they no longer form part of your estate. So even if something should happen to you, then these assets would be protected. And provided that you are not yourself a fixed interest beneficiary, these assets would be protected from claims by creditors, potentially by disgruntled spouses, and so on and so forth. I would just add a last one, which is very specific to Mauritian legislation, and I'm sure my colleague Faraz will dwell a little bit more into it. Both the Trust Act and the Foundation Act of Mauritius contains what we call firewall provisions, i.e. provisions which are aimed at preventing a trust or a foundation of being attacked, be it on the basis of succession rights, including forced heirship, marriage, divorce, or insolvency of a settlor or of a beneficiary. So this adds to the asset protection features of the trust or the foundation. For a foundation also, and that's very sort of important, especially in the context of African clients and also of Asian clients. We deal a lot with African and Asian clients. And one of the recurring requests from these clients is that they would like to have control and influence over the structure after it has been set up. It is more difficult to do that with a trust, because as I mentioned, when you have a trust, it is a trustee that has the decision-making authority. Although one could use a protector, it only provides for limited control and influence. With a foundation, it is a bit easier to do because the client can also be a member of council, and therefore by being on the board, the client can officially partake in the decision-making process and therefore exercise the necessary influence over the decision-making process. So to conclude, I would say that foundations have most of the attractions of a trust and can thus potentially be used for purposes that trusts are used for. Compared to the trust, which is a common law concept, the foundation will appeal to clients, I think, based in civil law territories where they are less familiar with the trust concept. They would appeal to clients who would like to have a structure that has legal personality to hold their assets. They would appeal probably more to clients who want to have a bit more control over the decision-making process. They might be a little bit more appropriate if the assets comprise of assets that are either wasting or volatile, because then it is less riskier to be held in a foundation as opposed to in a trust. But I suppose that at the end of the day, they both have their advantages and weaknesses and are probably of equal worth. When it comes to clients, it's very much a personal decision, and we would need to look carefully at each case because there is no sort of hard and fast rule of one size fits all. When it comes to estate planning, each client is different, their circumstances are different, and therefore we need to carefully look at each case on its own basis before proposing what structure is the best structure. So in conclusion, what I would like to say is that trusts and foundations are very beneficial when it comes to estate and succession planning. They enable clients to eliminate the issues that arise out of probate. They also allow clients to maximize the value of their estate. They ensure that wealth is adequately preserved, protected, but most importantly, and I'd like to end with that, they ensure that we manage this problem, this conundrum of wealth never lasting more than 3 generations, because they ensure that there is a proper plan for the wealth to be passed over. And that is particularly relevant to high net worth individuals that are also owners and managers of family-owned businesses.
In relation to personal succession planning, the Law of Succession Act governs succession and administration of estates in Kenya. For a person domiciled in Kenya, succession to immovable and movable property is in accordance with laws of Kenya. A person should have a properly drafted and valid will in place. I emphasize properly drafted, as a poorly drafted will leads to conflict and family feuds. If you don't have a properly drafted will yet, then please consult your lawyer and make one soon. If you have one already, please consider if it requires updating. If you do not have a will, then the Kenyan position is that the deceased estate will be distributed under intestacy provisions set out in the Law of Succession Act, such that one would lose control of how they wish their estate to be distributed, and it would go according to the list of next of kin set out in the Succession Act. The probate process takes very long in Kenya, could take up to 1-2 years, and in some cases may take longer. That poses a challenge, as until probate is obtained, the family cannot access the deceased's bank accounts or deal with any assets that are solely in the deceased's name. Thus, careful succession planning is important so as not to leave family members and loved ones in such a difficult financial position. There are a range of succession planning tools one can put in place. The focus today is on setting up a trust, a foundation, or similar structure. While planning your estate, you may need to consider whether it is appropriate to your circumstances to set up a trust or foundation in your lifetime and transfer some of your assets into the trust or foundation during your lifetime and also after your death. The trust can be set up locally or in an offshore jurisdiction such as Mauritius. Trusts and foundations, as Asad has mentioned, can be extremely useful instruments in planning long-term for the ownership of assets, including business assets. The major advantage is that no probate will be required on death, as the assets will already have been transferred in your lifetime. Transfer of assets into a trust structure or foundation would attract taxes such as stamp duty in the case of land or shares, capital gains tax in the case of land, VAT, and so on. However, if there is some tax planning undertaken, then the tax implications of setting up a lifetime trust or foundation can be mitigated in terms of long-term succession planning for a family. Furthermore, as Kenya has no inheritance tax, the settlor could make a will pursuant to which certain assets can also be transferred into the trust on the death of the settlor, bearing in mind that in that case, probate process would need to be completed. Transferring assets into a trust in one's lifetime reduces the chances of family disputes, ensures continuity of ownership, and no delays in terms of use of assets. It would be important to appoint lawyers and professional trust companies who are experts in this area and have good repute. They can assist in drafting a trust deed. It is important that a trust deed or a foundation charter is drafted properly and not just using any template without checking that it meets your wishes and requirements. Some of the advantages of a properly created trust and foundation are: it can be used as a good wealth management and succession planning tool, as the trustees would invest and manage the assets and would make distribution of income to the beneficiaries based on the beneficiaries' needs. The financial needs of the beneficiaries would thus be taken care of. Secondly, the assets that have been transferred during the settlor's lifetime belong to the trust, such that on the settlor's death, there is no requirement of probate in relation to those assets. If a will is contested, the probate process would take very, very long, and during this time, your loved ones would not have access to your assets. If your assets are already in a lifetime trust or foundation structure, then no probate is required, and the trustees would continue to benefit your beneficiaries. Any disgruntled dependent or creditor would not be able to claim against assets that are vested properly in a trust or foundation, as they do not form part of the estate on death. A dependent under the Succession Act of Kenya includes a former wife, a wife, and children, whether or not maintained by the deceased prior to death. It includes parents and other family members that the deceased was maintaining immediately prior to death, and a husband if a wife was maintaining him prior to his death. Where a person does not wish to provide for a particular dependent and avoid any claim being made against the estate on his death, then setting up a trust or foundation structure would assist, as the assets will be transferred into the trust in his lifetime, so it does not form part of his estate. The beneficiaries can be persons of the settlor's choice, and there are no laws in Mauritius relating to provision for dependents that a settlor has considered. Provisions can be included to say that if a beneficiary challenges his entitlement under the trust or foundation, then he will be excluded totally from his entitlement. On a divorce, the assets vested in the trust would not be subject to matrimonial proceedings and thus subject to division. The Trust Act in Mauritius includes provisions aimed at preventing a trust from being attacked on the basis of succession rights, marriage, divorce, insolvency of a settlor or a beneficiary. Kenya recognizes Sharia law. Depending on the sect of the Muslim, there are prescribed shares of how much each family member would inherit. Where a Muslim wishes to benefit his choice of beneficiaries, he may consider setting up a trust or foundation. The Trusts Act of Mauritius safeguards a trust's confidentiality. There is no trust register or requirement to disclose beneficial ownership. If a client wants to maintain confidentiality, avoid challenges to his will, maintain certain assets within his family, bypass probate formalities and the timescale involved in obtaining probate, have responsible qualified people looking after the assets so that it benefits future generations, then a high net worth individual could use a trust or foundation structure in Mauritius as a way of estate planning in relation to certain assets. With respect to corporate structuring, we have experience in structuring investments through Mauritius into Africa for our clients who have companies based in one country or who have a group of companies based across several African countries. Mauritius is a great holiday destination, but it is also an attractive jurisdiction with a network of double tax avoidance agreements in place with many countries in Africa. The double tax treaty with Kenya has been gazetted recently in Kenya and is awaiting coming into force. Mauritius has raised its profile as a finance channel for investment in Africa. It has good tax incentives. Faraz will briefly highlight these later. Mauritius has good legislation and a credible legal system. The Mauritius International Arbitration Center handles international arbitrations and mediations. If parties choose Mauritius as the seat of arbitration, they can take advantage of its legal regime for international arbitration. Any court proceedings are heard by the Mauritius Supreme Court, with any appeal heard by the Privy Council of England and Wales. Therefore, Mauritius is a jurisdiction which has political stability, double tax avoidance agreements, investment and trade agreements with a range of countries, tax incentives, and a good legal structure. Some Kenyan aspects to bear in mind. One needs to take legal advice as to what assets can be transferred into a trust or foundation. They need to consider tax implications and do effective tax planning. Depending on one's circumstances, solutions can be tailor-made to come up with effective tax-saving mechanisms when transferring assets into a trust or foundation. In Kenya, certain real estate, for example, cannot be held by non-Kenyan citizens.
And of being an ideal jurisdiction for wealth management activities. So my intervention today would build upon the salient features enumerated by the panelists before me, and I will articulate the advantages of considering Mauritius for such type of activities. As we all agree, when an exceptionally affluent person is looking for a jurisdiction for the domiciliation of his wealth, there are certain vital parameters that he or she looks for. And I begin with the first one, which is of paramount importance. That is the macroeconomic, social, and political stability of the chosen jurisdiction. Many attendees of this webinar may be aware but the Republic of Mauritius is a sovereign democratic state within the Commonwealth. The Constitution of Mauritius guarantees the rights of liberty, protection of the law, freedom of conscience, and most importantly, fundamental economic rights with regard to assets, specifically under Article 8 of the Constitution. We are independent since 1968. We are a parliamentary democracy with free and fair elections every 5 years. Having said this, the jurisdiction frequently tops indices, including African indices relating to political rights and freedoms, such as Established Rule of Law and Political Stability Index, Democracy Index 2019, the Economist Intelligence Unit, where they have given us the rating of full democracy, amongst others. It is, as we say, Joseph, Mauritius is a melting pot of cultures and religions, and we all coexist peacefully. We never had a civil war since independence, and I think that that is very important when you look at a jurisdiction for your wealth management and for your estate planning activities. But over and above this narrative, Mauritius continues to be rated Baa1 by the credit rating agency like Moody's. So we are an investment grade country in Africa, along with Botswana, Morocco, and Namibia, if I'm not mistaken. But if we juxtapose that to an international financial center or a business hub, we are the only investment grade business hub in this part of the world based on the ratings that those agencies provide us with. But in addition to the point made by Mona, the highest court of appeal in Mauritius is the Judicial Committee of the Privy Council in London. And I think this gives comfort to the exceptionally affluent and the high net worth individuals with regard to our legal system. Secondly, the second point which the high net worth individuals would look for would be the depth of the financial services sector. So allow me to just give a quick snapshot of that one as well. The Mauritius International Financial Center has a very transparent legal regime combining both the common law and the civil law systems. We have competitive operational costs. We have efficient financial system, and we have legal professionals. And all of these factors have emboldened investors to use Mauritius as an IFC for investing in Africa. The banking infrastructure is very important when we talk about private wealth and wealth management activities. And over and above the resilient banking infrastructure that we have in Mauritius, allow me to share that the capital adequacy ratios, which measures the liquidity of the banking system in Mauritius, is around 18.2%, which is much more than the average required by the Basel Convention. There is a robust legal environment and a business environment. There is no foreign exchange controls. We have an educated and bilingual workforce, and it is an important contributor to the GDP of Mauritius. But our unique selling point, if you hear me aside and you hear other practitioners as well, the unique selling point of Mauritius as a wealth planning jurisdiction is principally due to its people, to our people. The jurisdiction Mauritius boasts a skilled workforce, approximately 13,000 people working in the financial services center. These are highly trained professionals. They are ACCA qualified, STEP, the Society of Trust and Estate Practitioners, ICSA, lawyers, fund administrators, bankers, amongst others. And they have the ability to deal with modern international clients' exigencies. We are predominantly bilingual, English and French. So we break all communication barriers. The level of service is extremely high, and we are a hard-working culture, fast and efficient. And Mona already shared, we have an expansive network of bilateral investment treaties and double taxation avoidance agreements 45 bilateral investment treaties, 24 with African states. We have 52 tax treaties, 23 of which are with African states. And of course, what the international investors and the high net worth individuals would look for in a jurisdiction is the adherence and compliance to international best practices. So allow me to say in this third limb, Joseph, that after the peer-to-peer review by the OECD, and we have adhered, Mauritius had adhered to the BEPS initiative, which is the Base Erosion and Profit Shifting Initiative of the OECD. Mauritius has undertaken significant regulatory amendments and adopted enhanced peer review process. And I am pleased to share that Mauritius does not have any harmful tax practices, as was reviewed by the Forum on Harmful Tax Practices of the OECD, as well as the European Union's Code of Conduct Group. So we are on the white list of the EU Code of Conduct Group when it comes to tax matters, and we are on the white list of the OECD's Forum on Harmful Tax Practices when it comes to tax matters. Now, let me preempt a little bit, and there is a progress that Mauritius is making on the anti-money laundering and combating financing of terrorism activities systems, the AML-CFT, that is reviewed by the Financial Action Task Force. When the review of Mauritius started in 2018, we were compliant with only 13 of the 40 recommendations by the Financial Action Task Force. As we speak, we are compliant. So within 1.5 years, we are compliant with 35 out of 40 recommendations of the Financial Action Task Force, including the Big Six, what the FATF calls the Big Six. In addition to that, you know, the European Union has used the Financial Action Task Force list in coming out with its own list. So we are on the watch list of the Financial Action Task Force, and we will get out of the FATF list very soon. And by consequence, we will get out of the EU list as well, presumably by February next year. But just a little bit without taking too much of time, let me give an update on this one as well. We are on the watch list of the Financial Action Task Force / the EU because of the effectiveness of our AML-CFT. There are 58 recommended actions to assess effectiveness. Within 1 year, Mauritius has complied with 53. So we have 5 more. Five more recommended actions to implement in terms of effectiveness. There has been major progress so far, including the enactment of a new AML-CFT Act on the 7th of July of this year, the setting up of a specialized financial offences court, and the capacity development for all the operators. And finally, there is an inter-ministerial committee which is chaired by none other than the Prime Minister of Mauritius, and we are looking into implementing all the action plan of the Financial Action Task Force by September of this year, so that we may get out of the list by February of next year.